Welcome back, ladies and gentlemen. This is the Bearable Bull here. And I got this aggressively average content for you today. And today, we have Jeremy Hogan on, one of our favorite community attorneys, to discuss all the unanswered questions that everyone in the XRP community has regarding the final stages of this Ripple vs. SEC case. That's right. This case is not completely over yet, and despite the fact that we did get a favorable XRP ruling, with the SEC losing on the XRP as a security front, we do have unanswered questions, and this is one of them. James Filan, another community attorney, stated that in the SEC versus Terra Do Kwon case, the SEC has filed a pleading discussing Judge Torres's decision, and the SEC versus Ripple case, in which it states SEC staff is considering the various available avenues for further review and intends to recommend that the SEC seeks such a review. The SEC says XRP ruling was wrong, and it signals it will appeal it. Ladies and gentlemen, Jeremy Hogan responds and states, heading into a settlement conference, an appeal is the only weapon, the only ammunition the SEC has against Ripple. The SEC is negotiating from a position of weakness, and of course it says it will appeal. I don't think you could read too much into it, one way or another. And in my opinion, that's bullish news as far as XRP is concerned. Over the past couple days, we've seen XRP drop from the 84-cent higher price target we were just at to 73 cents. And in my video yesterday, I showed a BC backer chart showing that the XRP price was slowing down a little bit. When we look at that and understand that XRP does tend to follow Bitcoin, and Bitcoin does tend to follow the stock market, as well as an inverse in dropping DXY, we should have known that a tiny little correction was coming. But the big question is, could this potential final last nail in the coffin for the SEC be a settlement to finish things up? Could that final settlement be the last catalyst that XRP needs to finally keep on running up, along with Bitcoin running up? These are questions that need to be answered, but it's very important to note we're on the edge of our seats monitoring XRP every single day, making sure that this final leg up does get achieved, and we finally get to see more positive price action. Ladies and gentlemen, all the catalysts we've been waiting for years for XRP to finally explode are happening before our eyes. Don't get dissuaded. Don't get footed out. Don't be impatient. This is the greatest time to be alive for the XRP community. And before I cap off this video for today, we're going to have Jeremy Hogan on to answer any and all unanswered questions about the final steps about this Ripple vs. SEC case. As always, guys, I appreciate every single one of you. Now I hope you enjoy it.
We are live, everybody, and we have the famous Jeremy Hogan here, our community attorney. This is actually the first time I believe we do a video on YouTube. Believe it or not, I don't know how that happened, but you've been killing it, man. You just had an interview with Darren recently, but I wanted to touch on a couple things that I think the community is really curious to know about. We're going to power through. We just had a major decision with this case. XRP is not a security, but we hear a lot of the Bitcoin maxis trying to argue otherwise, appeals, this and that. And just to dispel a lot of the misinformation and confusion, we're going to power through, and it should be a lot of fun, and the community should gain quite a bit of confidence from what you have to say. So just first and foremost, brother, from what I can tell and from the information I'm gathering, there's no appeal that can change Judge Torres's ruling on whether or not XRP is a security.
That is absolutely my opinion, and here's why. So the first reason for that is that the judge couched her opinion as to whether XRP is inherently a security in what's called dicta, meaning it's not an essential part of the order. So she could have done this order and said that Ripple, violated the law here and here, and that didn't violate the law there and there, without even mentioning whether XRP is in and of itself a security. So it's not a vital part of the order. It's what we call a dicta. And so it's because of that, it's almost, I've never even seen it happen before. I've ever seen anyone try, but you can't go to an appellate court and say, hey, appellate court, have the judge fix the comma in her sentence. That's not what the appellate courts do. Appellate courts might overturn a judge on an essential part of order, but they're not going to overturn her on dicta. So first, because of the way she framed it, I don't think that the courts can overturn it on appeal. But maybe even more so, which is another thing I've been thinking of while I was on the airplane today. She found that certain sales of XRP were not sales of securities, right? Actually, she found that most of them were not sales of securities. And even if one XRP out there in the cosmos is not a security, well, then how, in the terms of a lawsuit, can anyone ever say that the XRP that you sell or on an exchange, like if you sold XRP to me, how do we know if that's the batch of the security XRP or the batch of the non-security XRP? Because security is a fungible token, right? We can't tell which is part of the security batch and which was sold as not a security. So even putting the whole dicta issue aside, which I think is unappealable, I also think that it can't be, even if it is overturned on appeal, which I don't think it can be, well then if there's ever a lawsuit on your sale of XRP to me, how would anyone ever know if the XRP you sell me is the security XRP or the non-security XRP? So, for those two reasons, I just don't see that one issue being overturned ever.
Excellent, excellent. I love to hear that. And something else that I'm very curious to know as well is, do you think that the SEC is unlikely to appeal because Ripple could also counter with an institutional sales appeal and play this game of back and forth and nitpick each other and really drag this out, while at the same time still having, as far as all of us are concerned, the decision that XRP is not a security, just that is the rule of the land at the moment?
Correct. Well, the first thing I would say is if the SEC appeals the programmatic sales or the other sales, Ripple will absolutely appeal as well. I mean, there'd be no reason not to at that point. So you're kind of playing a little bit of a game of chicken in litigation here, because if one side appeals, the other side is going to appeal, for sure. Because why, if someone throws a punch at you, why did you stand there? You're gonna throw a punch back, right? It's just you're playing the game of chicken at the bar, seeing if anyone's gonna actually throw a punch. And that's where we're at right now. So we have two drunk guys at the bar. Maybe a bad analogy, but we have two drunk guys at the bar. And it's just one of those, is this just all bravado and chest puffing, or is someone actually gonna throw a punch? Because if someone throws a punch, the other guy must throw a punch back. Otherwise, you're just gonna get hammered. So that's gonna happen. I really fast. I'm not of the opinion that the SEC is going to appeal, because there's just so much more for them to lose here than there is for them to gain. And I think that's at the heart of it. I wouldn't appeal if I were them, for sure.
So just because I know a lot of people are curious, what would they lose if they appeal and it didn't go their way?
So right now, what you have is a trial level judge saying that XRP is not a security, and that programmatic sales and other sales were not sales of securities, right? And it's an influential judge, and I don't mean to downplay this, because this is not, no offense, but this is not some judge from the middle of Central Florida opining on securities law, right? This is the Southern District of New York. This is where the Telegram case came out of, where the Kit case came out of, close to where the library case came out of. So this is not some, this is not some court that rarely ever sees a securities case. This is the heart of, that type of law. And so even though the judge is a very influential judge because they're out of the Southern District of New York, you still have only a trial level judge. What she says is not binding on anyone. But if the SEC were to appeal and it were to go up to the second DCA, now you have an opinion, and if the second DCA was to agree with Judge Torres, now you have an opinion that's binding on every trial court in the second DCA's jurisdiction, which is about, I think, 1/9 of the trial courts in the whole country. So now you have a very influential. Plus, you have an appellate court saying that blind sales of digital assets are not securities, And so that carries a lot more weight than just a trial level judge. And that's why I don't think the SEC is going to appeal.
And the reason that's important is because that would limit the SEC's abilities to come after the rest of these cryptos, which is something very important and something that I'm sure that they really want to go after as well. And kind of along those lines, I remember you saying, let's see, this is what I'm going to ask. Are other cases or cryptos to a certain extent protected, or are their cases improved from the ruling that Judge Torres made? Because I remember vividly you saying, and I agreed with you when you said this, that XRP will be freed by the time that all these cryptos are beginning to get screwed. And that's kind of what I think we're seeing now.
Right, and you're absolutely right. So this case helps other digital asset projects, no doubt about it. This case helps them. And the biggest benefactor other than Ripple is Coinbase, because of course, the whole reason that Coinbase got sued by the SEC is because they're alleging that 12 digital asset tokens that Coinbase is selling are securities. So when Coinbase and their lawyers saw this opinion, boy, there were some cheers going on in that law office for sure. So it really helps Coinbase. It helps other projects, but because of the way the Judge Torres made a very factual argument here, and also because of what we just talked about, that it's a trial level order, its presidential value is somewhat limited. So although it helps other projects, this is not so. For example, if a project were to come to me and say, "Hey, Jeremy, now that this order's come out, we're gonna go ahead and just sell our tokens. You know, we're building out, we're using the money to build out our platform. We're going to sell the tokens on the exchanges because now we're 100% safe, and we can do this because Judge Torres said so." I would recommend them, no, that's not the case at all. And if you do that, you might be putting a mark on your back. I would highly recommend you don't do that because you're still selling an investment contract. So this is not something that gives the all clear to other projects to go ahead and sell on exchanges, because that's 100% okay. And I don't think any lawyer is going to be recommending that. It's just a trial level judge saying this. And so the trial level judge is the judge that heard the XRP case. So it's 100% lock solid as to XRP, but it's not 100% lock solid as to other digital asset projects. I would say even less than 50% solid.
Now that's important. And I think another thing that's very important that I believe was found in this case is that, correct me if I'm wrong, Ripple and XRP actually lost on the fair notice defense. Am I right? Yeah.
So that's correct. That's correct. That was a little bit surprising. I'll just say one thing. So the judge did not rule in Ripple's favor on the fair notice defense, but she did include a footnote, which I thought was very interesting, in which she suggested that if she had ruled otherwise on the programmatic sales, that the fair notice defense might have been something that could have moved forward to trial. So although Ripple lost on the fair notice defense, it wasn't a complete loss, because the judge was suggesting that there might be something there in the future. Kind of like, you go on a date with a girl and, you don't go anywhere with it, but she says, "Hey, next time we go out, maybe something will happen." Another bad analogy, Bull.
No worries. I think people kind of are getting what you're saying, but the reason I find that so significant is it's kind of like a 50-50. They didn't lose, but they didn't win. And I feel like other projects were really kind of banking on the fair notice defense as well. Am I right? So that's not good for us too.
It's not good, and I was a little surprised that she was as dismissive of it as she was, and a lot of the lawyers thought that she would be dismissive. So I have to say I was wrong, and they were correct on that issue. But I would also just also point out that in that footnote, she doesn't say I would never, and the fair notice defense could never win. She just said, if I had ruled on the programmatic sales in the other way, then maybe the fair notice defense would come into play. But as to institutional investors, which is where she found the investment contract, there's no fair notice defense that could be applied there, and that Ripple could win on.
Interesting. Now that's very important, because that institutional side is something that directly affects Ripple's big business model. I think out of all of this, the XRP community got the massive win, full-fledged, zero doubt. We absolutely took it home. But Ripple's going to have to get slapped on the wrist a little bit. And with that comes a potential settlement, and that's something you actually talked about with XRP Darren just the other day. And I'm curious to know if if Ripple were to settle this out with the SEC, how would a settlement look like? Is it just a fine and all other decisions by the judge remain the same? Like, would around the $700 million be the fee that Ripple pays, something like that? Like, what would you speculate, just in your honest opinion, what would that look like?
Well, there would obviously be a payment of money from Ripple, and it would be couched as a disgorgement. So what would happen is, I don't know what the number might be. There's going to be arguments about that, but let's just say it's $500 million. What would happen is there'd be a fund set up, and a law firm would be put in charge. It'd probably be Holland and Knight would be the law firm that would be set up to disperse that money. So it'd be disgorgement mainly. So Ripple would have to pay that money into a fund, and then people would make claims. Ripple, XRP purchasers, it would be the institutional purchasers, it wouldn't be me and you, would make claims for reimbursement of the money that they gave to Ripple for their purchases. And so that would be the first part of the settlement. The more difficult question is what happens other than that, because obviously you have disgorgement, you have the penalty. The penalty would be going straight to the SEC, but that would be negligible compared to probably the disgorgement penalty. And then the second part of it, and the more difficult part to think through, would be what else? Because if you're talking about settlement, I believe that the reason the case didn't settle previously is because the SEC wants all sales of Ripple to register all sales of XRP with it, and Ripple's business model would not just does not allow that. And I think that's what's been the holdup. So if the SEC still has that in their mind that, okay, well, we'll settle with you, but you're going to have to register every sale of XRP moving forward from this point forward, I think that's going to be a big problem. But what this order allows is, I mean, the judge has kind of already, ordered this to an extent. She said that institutional sales were investment contracts. So the SEC could now go to Ripple and say, okay, well, in this case, we want you to register any sale to institutional purchasers, and you can freely, of course, sell programmatically where there's, where the purchaser doesn't know that they're buying from which seller. And if that's something that Ripple can do from a business perspective, then I assume that they would enter into that settlement agreement. If it's not something that they could do, well, then I think we won't see a settlement agreement. But that's the hang up, I think, and that's the problem. Is will Ripple and SEC now see eye to eye on how they can settle out that aspect of the case, which is whether XRP sales are registered or not?
Sure, but what would have happened if they didn't settle out, right? Like,
So yeah, sure. If they don't settle out, then they're going. Well, first off, yeah, they're going to the settlement conference. It looks like sometime. I'm not sure when they're going to arrange it. It'll probably be happening soon. The most likely scenario to me is that they go to trial next year on the Larson and Mr. Garland House's aiding and abetting case, which is a very difficult case for the SEC to win, by the way. And then after the trial is over, I think you might see appeals depending on how the trial goes. But if the trial goes well for Ripple, I don't think you're going to see any appeals still at that point. And so then at the end of the trial, you're going to have a final judgment, which is what we have right now is an order on the party summary judgments. But at the end of the trial, you're going to get what's called a final judgment. And then the final judgment, the judge will say how much Ripple has to pay, because they're going to have to pay something. And then that's all there is to. I mean, really, that's all there's going to be to the final judgment. I think people will be surprised because the judge only has the ability to order what the SEC asked for in the complaint and what the law allows it to order. And the only thing that the courts can really order for people is money at the end of the day. So it'll be a fine. There can be an injunction, but the only injunction that the SEC asked for in its complaint was that Ripple no longer violate law by selling XRP illegally. And so her final judgment would probably be, okay, Ripple, now you have to comply with my order. Otherwise, you're going to be held in contempt. So Ripple would have to comply with not selling to institutional purchasers the way that they did, that got them in trouble in the order. But then everything else would be fair game. So I think next year we'll see a final judgment, and I think it'll say basically Ripple pay a fine and don't violate my order. And if they did violate the order, if the SEC thinks Ripple violates the order, then what happens is they file a motion for contempt, and they go back in front of the judge and say, hey, judge, Ripple, you know, sold to, Bank of America, and they're not supposed to do that, and we want you to punish them for it. And so that's kind of the end of the case. A little anticlimactic, but that's how these cases go. But the big thing already happened in this case, which was her order on the summary judgments. That was the big thing. I think everything from here might be a little anticlimactic.
Hey, it's not anticlimactic for me. We won, bro. Oh, shit. Don't speak for yourself. I'm excited, man. But
no, the last week was awesome. I'm still in disbelief. It's when I read the order, it took me a while to process, of course, and then I tweeted my thoughts on it. It's one of these orders, where the more you read it, the more you like it. It's one of these orders when I first read it, I was like, okay, let's just split the baby. I was like, okay, this is good. But then after reading it 2, 3, I think I read it 4 times now. Every time I read it, I like it more and more. It's one of those orders that kind of grows on you, and I think it's more and more pro Ripple the more I read it.
That's really good to hear. That's really good to hear. I think, what do I have next? Yes, this is important. So my question is, so we know that the judge found certain sales of XRP to be part of a securities contract, and I'm curious to know, how can Ripple sell XRP to institutions for on-demand liquidity now in a way where it's not necessarily considered a security, or even if it could be sold the way it was before, but I'm just curious to know how they can still fund that part of their business.
It's a great question, and I don't have a good answer, to be honest. If I
Yeah.
had a couple days, I could probably come up with some better thoughts for you, to be honest. But uh, the only thing I could tell you is this: is the order was fairly specific, which I think helps Ripple because I guarantee you they have 25 lawyers thinking for the last week on that exact question that you just asked me.
Yeah.
Much smarter lawyers than me. So they're trying to come up with ideas right now. I've even seen some ideas thrown out on Twitter that made sense to me. But what I could guarantee you is that they're going to come up with some way that they can operate their business within the bounds of the order that was presented. I just don't know what it is. There's all sorts of different ways you could do these things. You could sell securities through a variety of means. And the nice thing, and the reason why I do think they're going to be able to come up with kind of a workaround here, is because it's selling to the retail investor that the SEC really is supposed to be involved in and protect people from. When you're selling to companies and when you're selling to sophisticated buyers, there's the law says, okay, look, these are sophisticated people. They're able to protect themselves. And so if the judges said selling to retail is the problem and then that's the sale of a security, that would be more difficult to work around than what she did, which is she said sales to corporations and very sophisticated investors or sales of securities. So I think there's going to be a very good workaround. I just don't know what it is because I honestly just haven't had time to spend a couple hours digging into securities laws to think of the workaround. There's Reg D exceptions. There's all sorts of this. They could register certain sales of them. Maybe they could even just register with the SEC and say, "Hey, SEC, we're selling 100 million XRP, and here's the person," and register that in effect. So there's going to be a workaround. I'm pretty confident in that. I just don't know what the workaround is.
Excellent, 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 excellent. Let's see. Is the Supreme Court now off the table?
No, the Supreme Court is not off the table. So the way this gets to the Supreme Court is it's a long road. Let me lay it out for you briefly. So this is in my mind how that happens. The SEC decides they're going to appeal. I think that's most likely to be an interlocutory appeal. So that's going to take place. That would take place next year after the trial. The SEC appeals, Ripple appeals. It goes up to the second DCA. Because of the way Judge Torres ruled on the case, which I thought she did it in a very smart way, a part of the case, at least, even if the second DCA disagrees with her, they'd still have to send a part of the case back to her for her to kind of reissue her order. So basically what you have is SEC appeals next year. It goes up to the second DCA. If they disagree with Judge Torres, it goes back to her for her to kind of clarify a part of her order on the common enterprise element, which she hasn't ruled on yet because she didn't even get to it. So then it goes back to her. She issues her ruling on the common enterprise element. Then the SEC has to appeal that ruling. If they lose, goes back up to the second DCA. That's going to be taking place in 2025 at the earliest. And then the Supreme Court has to decide that they want to rule on the case as well. And so that's happening in 2028, 2029, and we're talking a long time. And the more likely scenario than that even is that the second DCA rules on it, but the Supreme Court says, well, let's see how this plays out, because the Supreme Court only can rule on a handful of cases every year. They're very particular what cases they take. What the Supreme Court wants to probably see is they want to see the second DCA say this, and they want to see another district court of appeal say this, so that you have a conflict between the circuits. And then the Supreme Court usually will get involved and say, okay, second DCA says yes, the third DCA says no, now we need to get involved because there's a conflict between the appellate courts. If that were the case, you'd have to have another court rule on a similar issue. And if that takes place, you're talking 4 or 5 years from now. And until that happens, what Judge Torres says is the law of the land. So, good luck. That's a long time.
Hey, what you just said sounds so grueling and ultimately boring, dude. I couldn't even imagine it getting to that point. But
can you imagine being the attorney on one of these cases? My cases are bad enough, but these cases, you could your whole career could just be working on this one issue. 20 years of, and this is just the way the American system works, and it's not abnormal. It's not strange. If you're in the business, it's just this is the way it works, and the law. You can even, like, for example, I'll give you an example. So what we're seeing, what you're seeing, you don't maybe not realize it because you're not in the law practice, but what we're seeing is we're seeing case law being created before our eyes. We had all the way from the Telegram case, the Dow case, the Kick Interactive case, the library case, and now Judge Torres. You notice in Judge Torres's ruling in her order that she cites to all those cases before her. She cites to the Kick Interactive case. She cites to the Telegram case. She incorporates them into her order. She's a Harvard graduate. She's very smart. And so what she's doing is she's building off of the backbones of what's come before her, but she's changing it up a little bit. So she added her little spin to it. And now another court might add their spin to her, and the second DCA might add their spin to it. And so the way the law works in the US is everything builds off the things that come before it. And that's the way it's supposed to be, but it's supposed to happen slowly on purpose. And so I think what you're going to see is, XRP is in the clear. I think the other digital assets have a way to go because this is just the way the system works.
That's ultimately incredible because, we missed the last bull run pretty much. Like, we didn't hit our new all-time highs. We only went up to around $2. But something I was trying to say to everyone is, despite the fact that we missed that last one, we're poised to really take off and be the leader in this one. And I think that's kind of what, especially with these rulings, is what I'm getting. There is regulatory uncertainty with every other crypto, and it's honestly pretty exciting to see. What I do want to ask is, because I do have a genuine concern for other cryptos, because I'm kind of struggling and grappling with how this new SEC approach to getting cryptos under the security umbrella is really going to work. So we have this Coinbase case and this Binance case going on. I feel like they're slightly different in a number of ways, because I feel like Binance is more fraud and looking into that, and Coinbase is more, oh, these tokens are securities. My question to you is, what happens if Coinbase loses on some specific rulings? Do some of those cryptos like ADA and Algo automatically get declared securities? Like, how does that even work? Because they're not suing the actual companies, they're suing the exchange. And by proxy, does that go to the token?
That's a great question. Something I haven't thought through, but let me just do it off the cuff here. So if Coinbase were to lose and the court were to rule that jurisdiction lies with the SEC because the XYZ token is a security. So XYZ token has not been sued, so it has no effect to XYZ token because they're not a party to the lawsuit. but the precedential value that that case has on them is horrendous, and leaves them open to not only being sued by the SEC, but being sued by purchasers in some kind of class action, like what's happening with Ripple right now. So in effect, even though this is why I don't like the way the SEC is going about this, is because they're trying to roundabout sue XYZ token and not giving them an opportunity to defend themselves. But if things were to go bad and XYZ token was found to be a security in the SEC case, although it's not designated as security because they're not a party to the lawsuit, it would destroy them. It really would destroy them because they'd be open to private litigation. Even if the SEC decided not to sue them, on top of it, there'd be some class action lawyers just chomping at the bit to get at them and get as much money out of them as they can. So that would be kind of the effect that I would see from that happening. It would be a sad thing.
I think that kind of sounds like a little bit of a death sentence.
Yeah, exactly. It's just you're branding the cow for slaughter is what happens in that situation.
And this is just a hypothesis I've been formulating, but I'm curious to get your take on this. I've made an observation that a lot of the cryptos that are being accused of being securities, and a lot of the companies that have been sued already and have already settled out, like a Kraken and like a Nexo and like a Coinbase and Binance and Ripple and Algos and Adas, like these are the cryptos that are some of the main players and what you may call some of the more credible crypto tokens and companies. I've said on my channel before, I view the SEC as the arm of the government that collects a success tax from companies, right? And I've seen that a lot. It's like Tesla, for example, even Apple, other companies have gone sued by the SEC, boom, pay a fine, you're on your way. I'm curious to know your thoughts on the potential of an SEC lawsuit kind of being a way of choosing which cryptos will be here in the future. Because to me, a lot of these cryptos are going to go away. 99% of cryptos, in my opinion, are bullshit and are going to die. But a lot of the ones that are being targeted, I think, are going to be some of the main players that stay, exchanges included. I'm curious to know your thoughts on that.
Well, it's just a cautionary thought, because I think what we saw in the Hinman emails, which apparently played a very limited role in the judge's order. We didn't see that come to fruition like we kind of expected it. But what I think the Hinman emails did show us is it pulled back the curtains on what was going on behind the scenes there. And what you could tell from the Hinman emails, at least my take from it, was not only was it an Ethereum kind of free pass, but the way that the speech was written, and one of the attorneys that was reviewing the speech beforehand said, "Hey, well, you're just using criteria that have no place in the law. Where do these criteria come from?" And when you looked at the criteria were specifically to attack Ripple. It was like designed to go after Ripple, and I think that's where Ripple was so kind of irritated about the Hinman emails, is that it wasn't just an Ethereum free pass; it was literally an attack on Ripple because of the criteria that Hinman used in his speech.
See,
We'll never know. We'll never know maybe what Hinman was thinking, but we can, a lot of people are assuming it was ill thoughts. And so, my only thought on that is just we have to really be careful, because the SEC has that power to pick winners and losers. And so, I don't know if there needs to be more oversight or what the solution is, but I think definitely when you have a regulator that can do these type of things, and it looks, to me, it looks like there was something funky going on back there in 2018 with the Hinman speech. So we just need to be very careful, because once you go down that road where the government's picking in winners and losers, you're heading to a dangerous place.
yeah. Until we get to a place where there's more clear law made out from Congress, from what I hear, XRP has clarity, and we have to just have judges build on the Torahs and Kick and Telegram decisions and stuff like that. My question is, one, have you been seeing some of the bills that are being proposed by Congress at the moment? I think there have been two, kind of one limiting the SEC's regulation by enforcement approach, and two, have you seen anything that points to a potential more clear rule of the land for crypto from Congress at the moment?
Yeah, I think, the both of the bills that I've really reviewed in some detail, both I thought were pretty good in certain places, but were disasters in others. And
Hmm.
I love the clarity in some of the bills, but especially for like decentralized finance and that type of thing. I mean, if you're kind of a hardcore decentralized crypto guy, that you see these bills and you cringe because for example, KYC AML on a decentralized exchange can't exist, or else the decentralized exchange doesn't exist. So when you're trying to apply rules that apply to banks, and you're trying to apply it to decentralized finance, what you're doing is killing decentralized exchanges in finance. So I think the bills need a lot of work. The parts that clarify the security commodity stuff, I think, are pretty good in both of the bills. I think it's better than what we have now. And even if you don't have 100% clarity, in my experience, what you'll find is just give clear guidelines for what the rules are, and people will find a way to play in them. But when you have these vague, ambiguous gray areas of law like we have now, people don't know how to play in them, and therefore they're all over the place, including the fraud, including all the bad stuff that we try to stay away from. So I think certain parts of the laws are great, and and they should move forward. There's certain parts of the law that really need the blockchain lobbyist groups to get in there and say, hey, you can't do this because if you KYC a DEX, then you don't have a DEX. All you're doing is saying it's illegal. So you might as well just say it's illegal. Why even bother having rules for DEXs, right? So I think that's my general thoughts on it. I think there's a lot of work to be done, but it's a positive thing to really see those laws coming out of Congress, right? Because for the last 10 years, there's been nothing.
Yeah, understood. Two more questions for you, brother. Then I'll leave you to get some rest. I know you've had a long day. Um, ETHgate, and specifically ETH 2.0. Do you foresee any trouble for ETH on the horizon, my friend?
Um,
I wouldn't mind it, to be honest. Because honestly, I'm greedy. I want some cheap ether, honestly.
I gotcha. Well, the short answer is no. I don't think he's going to get sued by the SEC. I think that ship is probably sailed. I mean, in theory, they could. I'm not saying that it can't happen. Um, I think that the SEC has changed their priorities and changed their strategy. I think going after specific projects is not on their radar at this point in time. I think I was telling Darren this the other day. I think that's the smart move for them. Because even if you hit Ethereum, all you're doing is tying up, 6 of your lawyers in 5 years of litigation, possibly. I mean, at some point, even the SEC has limits, and it doesn't make sense to go after something that happened now, what, 8 years ago, 7, 8 years ago. I mean, it wouldn't make any sense for me for that to happen. So my prediction is no. I think Ethereum's free pass stands, and there's not going to be anyone going after them.
Unbelievable. I know a lot of people in the community that'll probably be frustrated to hear that. Probably seems unfair, but hey, emotions aside, it is what it is. It's the second largest crypto at this point, and we gotta move on. We got our win, my friends.
Yes,
I
sir.
think.
Yes, sir.
Last question for the day, brother. 75,000 XRP holders fought against the uh, fought against the SEC. Bless you to John Deaton for that. Will there ever be a payout towards those 75,000 XRP holders? What happens with that? Do things continue? I'm just curious to know.
Short answer is no. Again, and all
Oh,
the bad stuff at the end, right? But
yeah.
I don't. A lot of people on Twitter at least are talking about, can we sue the SEC? Can we do this? Can we do that? And the short answer is no. I mean, it's almost impossible. You have to show that someone at the SEC, or whoever it might be, intentionally uh, intended to defraud. Now, it's possible you could, but even then, there's just limitations on what you could do, because when you sue the government, you're basically suing yourself, right? Because we are all part of the government, and so there's a lot of limitations on how that happens, and whether you can do that. There's sovereign immunity, is what we call it, for a lot of most actions, and it's just so impossibly hard to do that I don't see the XRP holders being made whole.
Hmm.
But I will say that, look, and I think it was you maybe that pointed this out at some point in time, but you know, sometimes you look back on things in life, like for example, when I was in, it was 2008, I got fired from my job, and it was the worst day of my life. I couldn't believe I'd never been fired before, and they let me go, and I walked out the door, and I was like, this is the worst thing that could ever happen to me. My wife was pregnant with her first child. What am I going to do? And it was from that firing that I started my own law practice, which has been the best thing that's ever happened to me.
Yeah.
Amazing. I mean, just I can't imagine that would work for anyone else ever again. It's just been so amazing having my own law firm. But it all stemmed from the worst day of my life. So, and I don't know if it was you that mentioned this, but you know, the SEC suing Ripple back in 2020 or whenever it was might have been a major blessing in disguise in hindsight. We'll see how things go in the next bull run, right? So,
Yeah.
waiting to see how that all plays out.
I'm cautiously optimistic that that's the case, brother. But you shared a lot of perspective there. Sometimes what we think in the moment is a shitty situation can end up being the biggest catalyst for one of the better blessings in life. So appreciate you being open and sharing that, brother. Genuinely. Hogan, you're an absolute legend. I love you, brother. Everyone else in this community loves you as well. Thank you for taking the time out to answer some questions everyone had for you. And anything you need from me, don't hesitate to ask. Bless you, bro. Of
I appreciate you. Thanks for everything you do.
course, brother. See you soon.